Okay, well, Alan, you're gonna have to move. Okay, Alan, jeez. Okay. Alan, I love you. All right. Hello, Alan, stop moving this. Hello, everyone. I'm Dawn. Welcome to my channel. Thank you so much for visiting with me. So I was getting ready to go to bed, but this is something we really need to talk about. But first, if you haven't already, please consider subscribing to my channel, The Cutting Board. We do all kinds of things here. Shopping hauls, true crime, DIY, makeup, SFX makeup, vlogs, food content, and Disney content. But today we're talking about a case that is disturbing, heartbreaking, and honestly infuriating. And it's a case I've talked about before. There's just more to discuss now. And this is the case of Shanda Vander Ark, the Michigan mother convicted of torturing and starving her 15-year-old autistic son, Timothy Ferguson, to death. And we don't like this woman, right? So, and now, after being sentenced to life in prison, plus, she wants a new trial. Yeah, she wants a new trial. She thinks the result will be different, I guess. But why? Why does she want this? Because she claims that she was catatonic during the original proceedings, or a portion of the original proceedings, and that she received ineffectual counseling. And from where I sit, that man, with all the evidence against her, he did the best he could do. He really did. And today, we're going to break down the case a little bit, the evidence, and just her manipulation, and why her new trial request is, quite frankly, nonsense. But she has a right to do it, so... But before we talk about her behavior in court, we need to start with, what she's claiming now. I just think she's a ridiculous person. And I'm trying to be nice, but, it's hard sometimes. But her new attorney, Ronald Ambrose, has filed a motion for a new trial or a full evidentiary hearing. So, yeah. And the foundation of this motion is simple and absurd. He claims that Shanda Vander Ark was catatonic during her original trial, or rather a portion of it. Now, if you followed this case at all, you may have seen the original trial. At no point did she appear catatonic. I'm no mental health expert, but it doesn't take one to see that. I'm sorry, Alan is all up in my business, but it doesn't take one to see that this is completely fabricated. Catatonia is a severe neuropsychiatric condition in which a person becomes partially or completely unresponsive to the outside world. It affects movement, speech, and awareness. A catatonic individual may be unresponsive or just glazed over, detached from reality, unable to understand, what is even happening, and unable to assist in their own defense in a trial. Her attorney also claims that she was denied effective assistance of counsel because of this alleged mental state. So that's the story all summed up. That's what they're trying to sell anyway, that during the trial where she was accused of torturing her child to death, she was mentally unable to participate. And what I'm thinking is, why does it even matter? Because the evidence against her is profound. There's no defense for what she did. And the facts, they tell a very different story. They really do. And the evidence against her is still the same. Like, the evidence is all the same. The abundance of text messages that prove that she ordered her son Paul to do terrible things to Timothy, even suggesting pouring hot sauce on his privates. The video footage, her lies that just don't line up. It all exists. There's video footage of her mistreatment. To make sense of this argument that she was catatonic, we have to understand what catatonia actually is. And after I've explained it, that's not what she was going through. She is a fake. She is a fraud. She is attention seeking. And I would think, like, so in this evidentiary hearing, or, this hearing she had recently, she was, I believe, faking illness. And I'm going to show you some video footage of the judge talking about that, and I'm also going to show footage of her problems she had in her original trial, her problems.
We're delayed. There's been some concerns regarding Ms. Vander Ark's health this morning. Mr. Ambrose, if you want to go ahead and make a record of any concerns you have at this time.
Yes, Your Honor. I had a video conference with Ms. Vander Ark on Friday, this past Friday. It was concerning to me because she didn't appear to be her normal self, and so that concerned me. So I did send an email to the court expressing an adjournment if possible, just because this is an important phase in the whole appellate process, and certainly of utmost importance to my client that she's able to participate in a meaningful manner. And during our conversation on Friday, it just didn't seem that she was as up to speed or healthy. She expressed some health concerns that she was undergoing at that time, and so that's why I asked for an adjournment on Friday. What I understand is that what she told me this morning is on Saturday she had an episode at the Huron Valley Women's Facility where she passed out for a short period of time, was revived, but she had a medical issue at that time. She's not feeling well today either. I know that she was checked out by medical. Her blood pressure is higher than it is normally for her, as she self-reports. So I would be requesting an adjournment. It doesn't hurt the prosecution, I don't think, at all. It is, if anything, delaying this case keeps her in prison. I'd like to move forward as if I could, knowing in good conscience that we're putting our best foot forward on a case like this, and have the 100% confidence that my client is able to participate in a meaningful manner. And I just don't think at this point I can with any type of confidence say that. So I would still ask for an adjournment.
Thank you, Your Honor. Well, I was going to argue that she's presumed competent until she shows otherwise, but given that's not the claim, then the argument would be whether or not there's good cause for an adjournment, and it's the people's position that a headache is not good cause. Additionally, the people are ready to proceed and put, one, with the Ginther hearing, but two, we do have some evidence that we could set forth to make the record as it relates to her appearance and how she was on the transport on the way here. We did have after the in-chambers discussion, jail medical came and looked at her, and it seems that she's been cleared by them, apart from having somewhat raised blood pressure. So I do think that we could make a record as to why this is not good cause. Additionally, Ms. Vander Ark, through her counsel, did give a waiver of HIPAA so that we could request some records from MDOC. They said that those would be emailed to me in approximately 30 minutes. They were going to do that expeditiously. However, the people would put forth as an officer of the court that in communications with the Michigan Department of Corrections, they would not have transported her had there been a medical issue raised before transport. So, Your Honor, I think this is just, again, another dilatory tactic by Ms. Vander Ark to delay this hearing and to delay the proceedings. And I would say that there's not good cause. And additionally, I think the court can take into consideration all of the prior actions of the defendant, her prior reports, all of that when fashioning whether or not an adjournment is warranted. And it's not in this case, and we should proceed.
Participation, I don't think so.
Well, Mr. Ambrose, we're kind of in a catch-22 because I can't ask you what she's been telling you, and you know what kind of. I can't judge how much she's assisting you without getting into what she's talking about. So I'm observing her writing notes and talking to you, which I've had jury trials where the defendant doesn't say anything to their counsel, and so why don't we do this? The court also has experience with Ms. Vander Ark. Several times during the proceeding, during the jury trial, there were breaks in time where Ms. Vander Ark said she was undergoing distress. I granted those breaks. It seemed to me, and from the outside looking in, that these medical issues seem to be at times of pretty significant testimony in the trial. Not saying that maybe they weren't genuine, but they certainly appeared to be situational. Also, when she were at a preliminary examination down in district court, there was a point of what she claimed to be distress that appeared to be situational. We're here now, and I think it seems to be situational again. Again, she may be going through something, but I understand that adjourning this wouldn't necessarily prejudice the defense. However, there's witnesses here, they're ready to go, people took time out of their schedules, the court set aside an entire day for this. And there is something to be said for the swift administration of justice here. And so, based on what I have, I don't think there's good cause for an adjournment based on a headache, because that's all really the record's been made. And the only person that can judge if she really has a headache or not, quite frankly, is Ms. Vander Ark. And I don't know if she's telling the truth or not. I have no clue. I will say, as the finder of fact at the trial didn't find her credible, and I don't know how much credibility the court can lay on her statements. So I'm willing to do this. I can take a break, wait for the records to come in, that way the court can review those. I also can offer Ms. Vander Ark, is our jail staff allowed to give her medication, like ibuprofen or Tylenol or something like that? Is that allowed?
I would assume if they discuss it with healthcare at the prison, that would be fine.
Okay. All right. So I don't. Do we have something downstairs that she can? I mean, I don't know what she takes, Mr. Ambrose. She let me know. I'm sure they have it all on. We can do anything we can to help with that. I'm willing to give her, if she needs for blood pressure, I don't know, maybe she needs food or something. I don't know what it is. So anything that can accommodate to help her headache, I get it. If she's got a pounding headache, then I want to at least try to get her some help for that. So why don't we adjourn? We'll wait for the records to come in. Mr. Ambrose, let my staff know if she needs medication, and we can get that from the jail, and then go from there. All right, I did get a copy of the medical records. I'm assuming that we don't want to make those a part of the record, at least certainly not an open part of the record. I guess, how do you guys want to proceed with that? I can make them a confidential part of the record?
I would stipulate to any sort of protective order that the defense would want on these matters.
Mr. Ambrose?
That's fine.
Okay, so I'll make them part of the record. We'll call it the court's exhibit number 1. It'll be a confidential record. The court did have a chance to review those records. It looks like on the 22nd, without going into all the details, it's like on the 22nd, Ms. Vander Ark complained of that she felt like she was going to pass out. I don't think there's any indication in these records that she did in fact pass out. There was some concern with some thyroid issues when she was eating apples, I guess, and they basically told her, don't eat apples. That's what's in the records. So there's nothing in these records about her actually losing consciousness. She reported that she was going to pass out. There's also indication that she asked for some Dramamine for the trip to Muskegon because she typically gets car sickness. So that's kind of in line with the testimony that she felt sick on the way here, but she at least indicated that she gets car sick. So unless I'm missing something, it sounds like they sent her because there was no concern. So based on the records and what we've already done here, I think she's competent and we're going to move forward today. I am concerned that she reported losing consciousness when a medical person indicates that she complained of feeling like she was losing consciousness and that she's now kind of amplified for whatever reason, I don't know. But I am concerned about that, the fact that she misrepresented that to her attorney, potentially, that she actually lost consciousness because there's no record of that in the plea. So anyway, anything else before we move on, Mr. Ambrose?
Well, the only way that, just she would have to report to the medical personnel that she actually did lose consciousness. So,
Well, I mean, she okay, I get it, but the quote is, quote, I felt like I was going to pass out. I have tremors that are severe. That's what she reported on the visit November 22nd, 2025 at 6:45. And she was treated. She says the administrative note was that she was advised on site that the above patient came to the clinic concerned of dizziness and a tingling throat. The tingling throat was transient and only when she ate apples. And it says the RN advised patient had a reddened throat, no swelling, no lymph node enlargement noted. And eventually the treatment is, it says she did palpate in a large thyroid. However, the patient is, I don't want to get into that. It says RN still had concerns about patient's fall risk. The RN exam otherwise unremarkable. RN gave the patient detail prior to calling. I advised RN to tell the patient to stop eating apples. Other than that, I did not have orders for this patient. So that's what happened on the 22nd, at least according to the note. Like I said, I don't know what happened, but these are medical records by individuals that I don't know if they'd have a reason to lie, quite frankly, if they're making a medical record. So based on that, I don't see a serious medical issue that is to the concern of the court. So anything else, Mr. Ambrose, on that? I mean, she can testify if she wants about what she's going through. That's fine, but if the request is for an adjournment because of a medical issue, I don't see it, so. Well, I'm not, listen, I'm not gonna delay this anymore. This is, in my opinion, Mr. Ambrose, she's misrepresented and through you to the court that she passed out. She did not pass out. So I'm moving on. I think this is gamesmanship on her part, and it's now 11 o'clock on a hearing that we were supposed to start at 9 o'clock. The court's been very patient with this, and we need to go. So, anything else?
No, Your Honor.
Ms. Bloomquist. All right. So, Mr. Ambrose, this is your hearing.
Yes.
You can call any opening statements on either side, or you want to just go straight into witnesses?
we can go.
Disabilities as well.
Yes, sir.
And I don't know if Mr. Johnson went into those, so why don't
He
you
didn't.
tell the jury what your physical disorders are as well?
I have allergy-induced asthma. I am allergic to almost everything environmental other than animals, every different type of pollen and mold and weeds. And then I am a reactive hypoglycemic. I have been my whole life, but it was actually after Timothy was born, it got much worse. And they finally figured out right after I moved here why it what was going on, but it required, I can eat and my blood sugar will still crash. So I can pass out, I can be doing whatever and just pass out.
About 5, maybe 10 minutes. So I'll have you up your tired of the jury room. Please rise. All right, you may be seated. Just for purposes of the record, Mr. Roberts and Mr. Johnson had a sidebar with the court indicating, Mr. Johnson indicated that his client was suffering some distress, specifically a panic attack, and he asked for 5 minutes. I think that's reasonable. So at this point in time, the court is going to take a brief recess. Mr. Johnson, just please let the bailiff know when your client is well enough to proceed.
Thank you, Your Honor.
All right?
You look like that when you put him in the bathtub?
I'm sorry.
Your Honor, may we have a moment?
Yes. Ms. Vander Ark, do we have a trash can?
I did. I placed a trash.
You did?
Yeah.
All right. Would you like the jury removed?
Just a moment. I'll keep it.
All right, please rise.
Right now we got some people coming over to talk to you, okay? You have another son inside the house?
I have two. Yeah.
Are they sleeping still right now?
One of them is, yeah. The 20-year-old's awake.
He's 20?
No, the 20-year-old's awake.
Okay.
He's been wearing really loose clothes the last couple of weeks.
He's really skinny.
He's really skinny, and I didn't notice till this morning because he wouldn't, I asked him if he's okay, and he would not answer me. He's 15. He's been...
He has autism?
Yeah.
Like a high functioning?
Yeah.
Okay.
So that's what that was about. So please, take care of yourself. He's a respectful officer. He's assured me he's going to do a medical screening. I know you got medical problems. You have to take good care of yourself. This is a manageable problem. The law says you're presumed innocent. You know that. Okay? So don't assume the worst. Assume the best. Okay? But take care of yourself. I'll be back in touch with you as soon as I can. Okay? I do have to go. I'm heading out of state right now.
All right. You're going to be charged with child abuse right now. I believe it's the first or second degree. So it is a felony. So you won't be able to get out of jail until you see the judge, until the warrant paperwork's down there, okay? Which will probably be tomorrow. All right.
Sorry, I'm sorry.
No, I'm the bearer of bad news right now. You know? Yeah, it's been a bad couple days.
Had 6 months. I had a stroke 6 months ago.
Mm-hmm.
Sorry.
Nope, you're all right. I do have to handcuff you, but I'll do it in the front.
If my blood sugar crashes, I need that.
Are you diabetic?
I'm reactive hypoglycemic.
Okay. Do you take medication for that?
No. I have a service dog normally, but I didn't bring him.
Yeah.
For good reason.
All right. I can let you have that all the way up until the jail. But the jail won't let you bring in any kind of food or nothing. So if you want to drink it, you can always drink it now.
Just worried I won't keep it to my stomach.
All right.
I haven't been able to keep anything down
No.
the last couple of days.
I don't want you puking then if you're going to try to drink it.
I can try. We'll see. I don't know.
All right. So I got my down there.
Strength.
Pardon?
I don't have the strength to do anything. I wouldn't anyway. But did y'all lose an officer?
But I have to cover you.
Did y'all lose somebody?
Yes, a Detroit officer was killed yesterday.
I'm so sorry.
Yep. For a second, relax.
I'm sorry. Trash can. Trash can. I don't have anything in my stomach. I'm sorry.
You're all right. Do what you got to do.
Oh,
96.5.
I usually go 97 even, so.
Really? That's a little bit lower than normal. What's most? Bet you a lot of people ask, like, what the?
Yeah, when they see 98.6, they think, oh, that's good. I'm like, no, it's not.
I feel that if someone were truly catatonic in a courtroom, the judge would stop the trial immediately for liability reasons. They would be taken, or the person would be taken for a psychiatric evaluation. The trial would not continue. People would notice, you know, she wasn't catatonic. What Vander Ark is claiming now, it does not match the reality of what happened in that courtroom. And I don't know why she's doing it. The evidence is profound. And you'd think she'd just want to get this all over with. During her original trial, Vander Ark was alert, attentive, focused, actively writing notes to her attorney, writing notes for herself, whatever, whispering with her attorney, reacting to testimony, you know, tracking everything said in court. And she wasn't confused. She wasn't detached. She was present. She wasn't frozen or mute. She was plugged into every single moment. She was actively participating. She even took the stand against her lawyer's advice and gave long explanations, detailed responses, emotionally performative behavior. You know, she gave the performance of her lifetime, I think, and what prosecutors described as intentional lies, non-stop lies. She, especially when you push the evidence against everything she said, she argued, she defended herself, she engaged. These are not the behaviors of someone in a catatonic state. These are the behaviors of someone who knows exactly what they're doing. She's trying to work it. Her current claims contradict the visible, documented reality of the trial. And now we need to talk about the heart of this case for just a minute. Timothy Ferguson. Let's not forget there is a real victim. Timothy weighed 69 pounds when he died. This wasn't accidental. This wasn't a momentary relapse of proper parenting. 69 pounds at age 15, 5'7". He was emaciated. He was skin and bones. The evidence showed that he endured ongoing, deliberate, daily torture. Food was denied. The refrigerator and cabinets were locked. He was forced into hours-long ice baths. He was made to perform strenuous exercises as punishment. He was humiliated. He was forced to consume large amounts of hot sauce. And I don't mean Tabasco, I mean super hot sauce, like, I can't remember the name of it right now, but it was really hot. He slept in conditions no child should endure, no human should endure. This wasn't a moment of poor parenting. This wasn't discipline gone too far. This was a pattern of torture. The medical examiner ruled his death a homicide caused by malnutrition and hypothermia. Hypothermia in the middle of the summer. Yeah. The judge called it exactly what it was: systematic torture. That's what the judge said.
Well, first and foremost, for the individuals here to speak on Timothy's behalf, I appreciate you being here. It kind of struck me throughout the trial, who was here for Timothy. And at one point in time, I worried that we may not have anyone to give a victim impact statement. And that to me made me very sad, quite frankly. Horrified more than anything, but quite sad. And I'm happy that two individuals took time to be here from miles across the country. And out of the horrible situation, that makes me feel a little bit better. Not much, but a little bit better. Mr. Johnson makes the same argument today that he made at the trial, that this was just negligence. This was her not understanding what was going on. She was really trying to do the punishment. She was trying to be a good parent, and she just didn't realize that Timothy was in such a horrible condition. And I found myself, especially during the closing argument, quite frankly, finding myself almost believing that. And afterwards, after the trial, I sat in my car after leaving that day, trying to understand, why I could feel that way. And what I realized is that I wanted to feel that way because I didn't want to accept the reality of the situation here. And the reality of the situation here is that this person, Ms. Vander Ark, you intentionally engaged in these acts. This wasn't negligence. This is not understanding why, but you intentionally did this with a goal. And I think Mr. Johnson's correct. I don't believe there was an intent to kill here, because you would have lost the very thing that you wanted to torture. Without him, you have no one to torture, except maybe the younger children. So I don't believe you intended to kill him. I think you intended to continue on torturing him for as long as you possibly could. The why, I don't know. But all the information that I have in front of me, and I sat down, I really thought about this, and I looked over my notes from the trial, demonstrate that this wasn't negligence. This wasn't you not understanding what was going on. You look through, I read through every single text message of the exhibit, 2,000 plus pages, to try to understand what the heck was going through your mind. And what became entirely clear to me is that you knew exactly what you were doing. Immediately afterwards, when police arrive at the home, you immediately concoct this lie about he's been on a hunger strike. He was in the bed and I checked on him and I gave him some food and all this stuff. You got Paul involved in it. At one point in time, put baggy clothes on him. Put clothes on him to make sure, I guess, that he looks like he was actually wearing them, that he was hiding his poor condition, even though you already received text messages, weeks earlier of how bad he looked. You testified yourself how highly intelligent you were. In fact, that's the only thing that you testified to that I think was actually true. You were quite proud of that, boasting how intelligent you were. And not only that, but your actions in hiding this child. You hid him from his grandparents. You made sure that your other son, G, or little man, as you call him, didn't see him. Those text messages talk about not wanting anyone to see him. I want to see him in that condition. You made sure that the garage was closed. When you sent him out there with no pants on to clean out the garage. I don't want to believe it because I don't understand. I can't wrap my mind. I've been trying now for this entire case to wrap my mind around about how somebody could do something so horrific, not only to another human being, but to their own child. I'm a father myself. I love my kids. I love them with unconditionally. But quite frankly, there's a mother's love that I've seen that is striking. And anybody who's a parent who's married, most mothers, not all, but most mothers have such a strong love for their children. And to see what you did to your own child, I don't know if there's a word in the English language to describe how to describe it. I only can come up with just horrific. You intentionally and systematically tortured this child. And let's call it what it is. It's torture. You tortured this child. This wasn't punishment. This wasn't trying to curb his behavior. You tortured him. You monitored him obsessively. You all the things you did. I looked through every one of the messages. Bread with hot sauce, wall sits, up and down the stairs, sleep deprivation, ice baths, making him puke up food, monitoring his bathroom time, giving him 60 seconds in the bathroom if he went to urinated, or 5 minutes if he had a bowel movement. You made him sleep in the closet. You threatened to make him sleep in the garage. You put Tabasco directly in his mouth. You made him put his hands over the head. Made him work in the garage with no pants. And there's two other things that didn't come out in the trial that were in the messages. One, that there was talk of blindfolding him, depriving him of his physical sight as a punishment. And the last thing that struck me is just absolutely horrific in terms of your thinking. There was mentioning of giving him salt water as a punishment. One of the text messages talks about, hey, tell Paul or tell Tim that I'm not going to do the saltwater punishment. And your reasoning for not punishing him was that, oh my God, we can't get him salt water, that could hurt him, that could kill him. But it was because you didn't want to give him another excuse to sit down on the toilet because he'd have diarrhea. He'd have diarrhea, and so he would have an excuse to sit down for a few more minutes while he was diarrhea from salt water. That was your excuse. That was your justification, not that it would hurt him. And you did so for what? Because of some punishment. You wanted to regulate his food, even though you yourself testified that he didn't really gain a lot of weight. Toward the end of these text messages, you and Paul are talking about not wanting him to win. He's not going to win. I didn't allow pictures to be shown in open court of Timothy as he was when he died because I didn't want people to remember him like that. of all the things you took away from him, one thing I didn't want you to take away from him was at least some shred of dignity. And then I also thought, well, I'm a judge, I'm a human being. I don't know how to right this wrong. We try to do that. I try to do that from the bench every day. There's no way to right this wrong except impose a sentence that essentially takes away your freedom. And I thought to myself, what do I do? And I will tell you this. I'm choosing not to remember your son dead, looking like a Holocaust victim, and I'm choosing to remember like that. And you can't even look at him. That's how he was. A beautiful child with a lot of life in his eyes. That's who your son was. And you took that from him. I'm choosing to remember him as a happy individual with life, not as an individual. And that's the picture I want people to remember of your son. You took that from him. You took it from him. For what reason, I don't know. Mr. Johnson's right. There is something broken in you. I don't know what that is, but it doesn't negate what you did here. So, besides remembering him like that, I'm not going to let you hide in the darkness anymore. People know what you are now. They know what you did. You're not able to hide in the darkness anymore. Timothy won. And he won because we know what you did to him now. It's not hidden anymore. We know who you are. That's the way that I'm going to honor him. You don't win because justice, thank God, in this case prevailed. I can't even imagine if you had been able to resuscitate him. He'd be still suffering. So if there's anything I'm grateful for, would be that he finally passed away so you couldn't continue to torture him like you did. It's a sentence of the court. First as to count 2, child abuse in the first degree. Court sentences you 50 years to 100 years in prison. Credit for 575 days. Court is exceeding guidelines in this case. The court finds that the amount of torture that I've indicated in terms of the long-term suffering that Mr. Ferguson, Timothy went through justifies on a reasonable grounds to depart from the guidelines. Used to be the standard was the guidelines. If the guidelines didn't take into consideration all the elements, I don't think they would take into consideration the amount of absolute systematic, consistent torture that you engaged in here. I think that's enough reasons to justify departing from the guidelines. There's a $68 state cost, $130 crime victim rights assessment. As to count 1, felony murder. It's a sentence of the court. You serve a term within the Michigan Department of Corrections for the rest of your natural life without parole. Again, there's credit for 575 days that you've already served. There's a $68 state cost. The crime victim assessment fee has already been assessed, and the court is going to assess a $450 public defender fee. Ms. Vander Ark, you have a right to file an application. You have a right to file an appeal. Request for this, if you are unable to afford an attorney, one will be appointed to a public expense. Request for assistance of a lawyer must be made within 42 days from today's date. Clerk is handing you a form that you must complete. Return to court in that 42 days. Mr. Roberts.
Judge, just briefly, I believe you did indicate you would order that $5,000 in restitution.
Oh, I did. Thank you, Mr. Roberts. The court will order $5,000 in restitution at this time to the Michigan Department of Health and Human Services, with the caveat that Mr. Johnson, you can certainly, if after the documentation, you can certainly ask for a restitution hearing and to contest that amount.
Thank you, Your Honor.
Anything else for the record, Mr. Roberts?
No, thank you, Judge.
Mr. Johnson?
No, sir.
All right, we're adjourned.
Vander Ark was convicted. She was sentenced to life without parole for, murder. plus 50 to 100 years for CA. She's never getting out, not with that evidence against her. So now, fast forward, a year after being convicted, about a year, Vander Ark suddenly claims that she was catatonic all along and that she had ineffective counsel. At the evidentiary hearing, the dramatics were back. They were. She didn't feel well, y'all. She didn't. And we're supposed to feel sorry for her? After what she did, we're supposed to feel sorry for her. But she couldn't continue. She needed attention. She needed sympathy. She needed the focus on her again.
Best you can. It's a matter now pending. Do you swear or affirm the testimony you're about to give you the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, put your hand down and grab a seat. Please state your name for the record and spell out your first name and last name.
Shanda Vander Ark, Shanda Vander, space capital ARK.
Go ahead, Mr. Ambrose.
Ms. Vander Ark, you heard the, well, first off, your medical condition. Let's just briefly go through that. How's your condition right now?
I'm miserable. I'm lightheaded. My head is just splitting. The back of my neck hurts constantly. It's something that goes along with the thyroid issue, I guess.
Okay.
I've been shaking. This is almost constant now. It started a couple days a week for a few hours at a time, and it's almost constant now.
Would it be your preference to testify at another time?
Absolutely. I feel like garbage.
With that, Your Honor, I would renew my request for an adjournment.
Can I have a sidebar with the attorney real quick?
Okay. Yes.
We're back on the record. People versus Vander Ark. Ms. Vander Ark, you can stand down. You can go sit next to your attorney. This is, as a practical matter, 1:49 p.m.
When she's in control, or what she thinks is control, she's fine. She's sharp. She's engaged. She can lie, argue, and strategize. But when the consequences hit, when she can't control the narrative anymore, when manipulation stops working, she collapses, and this is often referred to as a narcissistic collapse. I'm not diagnosing her, I'm just saying, like a petulant child, but instead of a knockout throwdown fit, which is what would normally be how it would manifest in someone, a narcissist, hers in this situation manifests into poor me syndrome. I don't feel sorry for her at all, and I don't think any of you do either. It's an act. She wants pity when she showed none ever. The lies stop landing, the theatrics get bigger, the fragility becomes an act. It's ridiculous. The person, her, spirals because they're no longer the center of gravity, And her sudden catatonia, her illness, her inability to continue, these are tactics. That's all they are. They're not symptoms. They're not real. And the judge can see it. The attorneys can see it. Most of us can all see it, right? Most people following this case can see it. I'm sure there are people out there that just are siding with her for whatever reason, but most people can see it. So where does this leave us? Right now, the judge has not ruled on whether she will receive a new trial or a full complete evidentiary hearing on her lawyer's performance, I guess. But given her behavior at trial, the overwhelming evidence against her, and the manipulation, how she tried to manipulate the court and the court's skepticism. Her chances are extremely low, and they should be low. She doesn't deserve another trial, and the evidence is the same no matter what. Vander Ark's credibility is damaged. Her claims don't match the facts. The evidence is piled against her, and the suffering Timothy endured cannot be erased, ever. And here are some interesting clips of her former attorney, Fred Johnson's, I think that's his name, Fred Johnson, his testimony this recent hearing, and I think you'll find these very interesting.
Why did you concede manslaughter?
The volume of evidence and the type of evidence was massive. And if you look at a jury and you tell them that nothing's wrong when it's clear to even somebody hasn't paid attention that something wrong's happened, you lose them. And when you lose credibility with the jury, they never listen to what you have to say after that. Quite frankly, I was hoping for murder too. I told them manslaughter because that would give them the space to move up but I was hoping that they would see me as a fair dealer, as an honest person who looked them in the eye and told them this is what's going on, and I'm not going to try to lie to you or put up lawyer tricks and fool you with the gun. That glove doesn't fit it, you must have quit that stuff. I'm an honest guy, this is what I honestly think, and this is why you should think it. So I had to concede something because, quite frankly, the evidence was overwhelming, and the prosecutor hadn't even put in his best evidence.
And is where you have somebody who absolutely can assist you in any aspect of the court proceeding?
Yes.
Was that the case in this case?
No.
Okay. And during trial, was Ms. Vander Ark alert to her being Ms. Vander Ark?
Yes.
Was she alert to, she was in Judge Casel's courtroom?
Yes.
And that it was the date and time that it was that year?
Yes.
Okay. And she was actively assisting you, it sounds like?
She was.
Okay. And was she assisting by writing notes while you were at counsel table?
Yes, and that was what I do is I can't listen to the witness chair and my client at the same time, so I give them a pad and pen and ask them to write notes and slide them over to me.
And without getting necessarily into what she was writing, was the content of what she was writing coherent?
Yes.
It was attuned to time and place?
Yes.
It was appropriate for what was going on in the courtroom?
Yes.
Okay. So let's talk about Thursday after she testified. Now, you don't to that question?
I used it in the layman's vernacular as competency, not as in the legal standard as competency. I didn't mean that she, as lawyers know, that she couldn't participate or that she couldn't understand. I didn't mean that. I meant as a layman would use the word competency. She just wasn't ready to go. She wasn't able to write me those notes or whisper in my ear or to participate as I would want her to have. Her life's on the line. It's a murder trial. I want her to be fully able, I'm going to say competent again, to participate in the process. This is her chance. This is her chance. And I didn't want her to leave that courtroom thinking that she left cards on the table or whatever the expression might be.
So it was not your impression that she was legally incompetent the morning of that Friday morning?
That is correct.
Okay. Why didn't you present those experts?
The conclusions the experts provided would have been supportive of a verdict of guilty of murder. Their positions were uniformly and enthusiastically negative towards my clients. They would have been prosecution witnesses and we presented their findings.
So you intentionally did not call these experts?
That is correct. We intentionally did not call them.
And that choice was made after a thorough investigation of their opinions, correct? Or I guess explain the investigation that went into that determination.
Dr. King, for instance, when I spoke to him, his response was, she's a monster. His response was, she's the worst thing he'd ever seen. And he's a man who testified for mass murders. I did not want to bring his testimony in.
This case is tragic, it's infuriating, and at its core is a child who suffered because the people meant to protect him, to love him, to care about him, chose cruelty instead. And don't get me started on Paul, his brother. Timothy deserved safety. He deserved care. He deserved to eat. He deserved to eat, and he deserved childhood, which he was denied what seems like his entire life. Instead, his life became a series of punishments, starvation, and pain at the hands of his mother and his older brother. And now, a year later, the person responsible wants to rewrite history. She wants to be a revisionist, claiming she was catatonic, incapable, mentally absent. But even if she was, none of this changes the evidence. And the courtroom saw through it then, and the judge is seeing through it now. I'm sure he saw through it back then also. But he has to be, diplomatic. Justice, as well as it can be, was done for Timothy, and from where I'm standing, it looks like it's going to stay that way. Hopefully. But even if she gets a new trial, she's still going to be convicted. The evidence is ridiculous against her. I'm going to, and I don't mean ridiculous like silly, I mean ridiculous like it's such a crazy amount of evidence. So I'm going to attach some clips from the hearing. So I'll say goodbye here and let you watch, but just various clips. And anyway, I'm not going to say I hope you enjoy it because it's not enjoyable, but it's just, she thinks she's something special and unique, and she did this to her child, and she doesn't deserve to be free, and she doesn't deserve another hearing. So that's it for me. I'm going to insert those clips, so continue watching, but I'll say goodbye for now.
Did it ever appear as if Mr. Johnson was just going to do things his own way without consulting her or taking her feedback?
Not at all.
Okay. Was he receptive to collaboration with her?
Yes.
How was her demeanor in those conversations?
I would say that she seemed very engaged. She was very eager to offer her own thoughts and feedback about kind of case strategy, and it's, I guess, demeanor, mood-wise, I mean, she seemed, I guess I'm repeating myself, but the best word I can think of is she seemed very engaged.
Now, you did mention, though, that she had thoughts on strategy. Were you present for discussions on trial strategy?
Very minimally.
Okay. What was your minimal involvement on that? Or at least what did you observe, if anything?
I want to make sure, I guess, that I recollect as clearly as possible, so excuse my pause. The conversations that I remember involved talking about obtaining an expert evaluation, a psychologist, to evaluate Ms. Vander Ark, and we all agreed that was a good next step. So that's the primary discussion that I recall as it pertains to strategy.
Okay, so obtaining experts and seeing
Yes.
what their opinions would be.
Yeah, if we were waiting for the psychologist to report back to us about his findings, or I guess that's the primary thing. I can't recall anything else specific.
Did you assist in sort of facilitating the interviews with the expert witnesses?
Yes.
Okay. And specifically, did you assist in, or did you participate in the interview with Dr. King?
Yes.
And when I say that, I don't mean your interview with Dr. King, I mean the
Correct.
defendants, correct?
Correct.
Okay. And ultimately, at the end of that interview, was a preliminary assessment given by Dr. King?
Yes.
Okay, what was that?
I guess to clarify, I am not the person who initially contacted Dr. King to arrange the assessment. I believe that was done by the social worker that was employed before me. When I was hired, that is when I kind of took over that role. I did participate in the interview with Dr. King, and after Ms. Vander Ark had ended her portion of the call, Dr. King and I were still on the call together, as well as I think he had a research assistant that was present. And I am not quoting by any means his exact words, but his initial or preliminary assessment was that he did not feel that Ms. Vander Ark was incompetent or severely mentally ill, and felt that he could not provide a good defense for our office.
Was Mr. John her before court every day of her trial?
Yes.
And this was the last day, correct?
Yes.
And did she appear catatonic?
No.
Did she appear to be conversational?
Yeah. Talked.
Okay. Anything about your conversation with her that made you think that she was having a mental health episode?
No.
Okay. Thank you. I have not.